Mr. Norris Quakers, Senior Advocate of Nigeria, joins us next to look at some of the judgments that have been delivered by the courts as a result of the tribunals in cases where there were first instance. Thank you for coming on this morning.
My pleasure.
Well, we still have people who are raising questions about this judgment, saying, well, that raises a big question about justice delivery in the country, and they cite different things. Well, many will say, look, yeah, if you lose cases, but some of them say, look, it's the first time in their entire practice that they see certain things go certain ways. What's your impression of what you've seen?
It's always been part of the system. Judges are human beings, subject to human foibles and weaknesses. Now, the beauty of our system is that when a court of first instance delivers a judgment that you're not comfortable with, the appellate court is there to reverse it. And if the appellate court also delivers its judgment, you're also not comfortable with it, the apex court, which is the Supreme Court, is there to do so. Now, there are instances when you could have some judgment that you might have cause to question. Like I remember not too long ago, the president of the bar said that when a court or even a lawyer stands the law on his head, is evidence of corruption. So these are things that must be looked into. But essentially, the court system is such that when the judgment is delivered, you're dissatisfied, you're not comfortable with it, you are empowered to challenge that judgment without necessarily going on the pages of newspaper, which is what a lot of people do. It's also not too advisable, not too good to denigrate our court system. It's not palatable for us to continue to run down our judges or our judicial system. This you will not find in developed societies. The law is already in place. Now, if you have evidence of corruption or corruptly induced judgment, a judgment that is influenced by monetary consideration, it means you can take it up if you have the allegation. And the CJN has said it's not enough to castigate judges, it's not enough to abuse judges, it's not enough to say that the judgment has been influenced. If you have evidence to show that indeed that judgment has been influenced, bring it forward and it will be looked into, and whoever is involved will be dealt with. Mind you, some justices of the Court of Appeal some time back were actually dismissed from the judiciary. So you have a system in place that can also deal with such allegations if the allegations can be substantiated.
But is anybody looking into, or shouldn't we, into why is it that many comments are beginning to make the round to the dailies about how they are dissatisfied with judgments? It wasn't so previously, but these days it seems to be increasing.
Well, it's like I said, it's not out of place to hear such things. I remember what Justice Ilori said, one-time Chief Judge of Lagos State, who is retired now. He said cases are won and lost in chambers. Sometimes we blame judges. We also need to look at what has been placed before. We get sentimental, we get emotional. You also need to look at what the lawyer has filed, what the lawyer has placed before the court. We have judicial authorities to the fact that the courts do not comport themselves as Santa Claus. The court is not a Father Christmas that will give you what you have not asked for. And the court will not aid you in giving you judgment if what you have placed before the court is not enough. Because oftentimes you also find a situation where lawyers file processes that are incomplete, processes that are not well detailed enough, reliefs that are not so clear, and you cannot expect the court, because our position is that you cannot find the judge descending to the arena of conflict. The court must not be seen to aid any side. The court must be seen to deliver justice without fear or favor, and that's why the maiden of justice wears a blindfold, because that is the essence of the judiciary.
But we cannot say in this time, I mean, in this particular case, that this senior advocates did not know what they were presenting or how they filed their cases. Do you think that could also that could have happened?
It's not impossible. You see, mind you, it's a human system. Sometimes some of the seniors are so busy that they also do not really have time to look at the nitty-gritty. You see, you can't really blame the judges. It's a system failure. It's a system thing. If a matter is filed, and for some reason, certain things that ought to have been there are not there. Sometimes some processes are filed without adequate research. I was saying to a group of lawyers who came to see me and we were having a discussion. I said, when the Pfizer case was filed by the current vice president, I had cause to get a copy of what was filed. And when I saw the work that was done, I was impressed. You see, it's not enough to just simply approach the court. What are you asking the court for? What are the facts that you are placed before the court? What is the relief? What are the documents in support? And there are a number of things that plays out when you go to court. So it's not in all cases that one can blame the judiciary. The lawyers themselves, whether senior advocate or junior advocate, the fact is it's still a lawyer. And we're also human beings. We're susceptible to errors. There are certain things that you can't divorce from the human composition.
You know, if you look at this critically, what also comes to mind is trying to see if sometimes there's some kind of handicap somewhere. As a lawyer, are you likely to have your own investigator to help you in pushing your case? Recall we used to have a series growing up called Maddox, and how he goes about his own cases. Do we have that? Do you have the services of the police or in private investigators to also help you, so that at the end of the day, you know that, well, this is justice really well delivered without having any problems?
I agree with you. The challenge we have is this. There is no particular law that says that we must have them, or that if you fail to have them, it will hinder or impact negatively on your case. Now, you have some lawyers who actually do that. If you must go the extra mile, for instance, when a client engages, you need to have a group of professionals offering different services in relation to the case that has been placed before you. Now, there's a particular case that we're doing, which is exactly in line with what you have just suggested. I read a book sometime back written by Johnny Cochran, the man who did the O.J. Simpson's case, and it inspired me a lot. It's something that we do not do here. It could be because we're not exposed. It could also be that because of the foundation of our society that is embedded on selfishness, greed, it's difficult to have a group of people come together for the purpose of ensuring that a watertight case is presented before the court. So it's actually a challenge. But that is not to say that we cannot do it if you want to. If you want justice, and you need to go the extra mile. Let me give you a particular example. If you have a criminal trial, for instance, someone has been alleged to have murdered a person. There are a number of things that should be done in addition to what the prosecution is going to present. As defense counsel, you're expected to go the extra mile as well. You must have your own expert. Now, in the Evidence Act, you also have provision in relation to expert witnesses. Prosecutor will bring his own expert witness. Defense will also bring his own expert witness in relation to the issue before the court. So it's not as if it's not something that we cannot do. The will to doing it is just not there, and that's the challenge that we have. But you have some lawyers who do that from time to time, and they get by. They get by.
Just wondering though, if you've taken a look at the appeal court judgments, some of them, I mean, for Rivers and for Akwa Ibom as well, there's been plenty of political back and forth between the two parties or at least the two major political parties on that one. What is your own reading of you know, the judgments that came out of this?
Let me first start with Akwa Ibom. I'm not surprised that the Court of Appeal overturned the decision of the tribunal. I mean, for crying out loud, if you are alleging that a certain number of constituencies within the state you observed irregularities, and for that reason, election in those areas were cancelled. Question then is, why then do you save the election itself? It naturally follows that if there are allegations of malpractices, irregularities, and all of that, and it's substantial, the natural thing to follow is cancel the election and then conduct a fresh one, and that's exactly what the Court of Appeal has done. Now, in relation to Rivers State, you have a situation where once a judgment is delivered, people are bound to complain. There must be a winner, there must be a loser. And I think the time has come for us to have a good sportsmanship posture. What exactly did the tribunal nullify the election? He went to the appeal court. Appeal court has upheld the judgment of the tribunal. It naturally follows. Now, because there are constitutional rights that are recognized, the loser, that's the respondent, is empowered by the Constitution to go further to the Supreme Court to determine whether what the tribunal pronounced and the Court of Appeal confirmed can be sustained. It is constitutional right. But I think we must also be sportsmen. We should be sportsmen when it comes to pronouncement of judgment. You evaluate, you look at it. I like what one of the key actors in Rivers State said when he was interviewed about this, that whether we like it or not, because of the popularity, in quote, of the ruling party in the state, that even if an election is conducted the second time, who won the first time will still win again. I mean, he was just saying that, that even if it is taken for review, the outcome will still be the same. The same thing the man in Akwa Ibom said, if your popularity is strong, and if you're so good, but there are certain irregularities that have been observed by the court, and as a result of which the election has been nullified, there's nothing stops you from going to the polls the second time. If you're certain of your victory, if you're certain of your popularity, if you're certain of your general acceptance by the public, I don't see why you cannot go back again to contest the election.
Are you worried that most of those cases are getting to the Supreme Court?
Yes, I am. Let me be honest with you. I'm one of those who believes that perhaps we need to review our laws. A situation where the incumbent has access to the treasury of the state. What happens eventually if, for instance, not only do you have the election nullified, supposing the incumbent is declared a nullity and is thrown out of the office, what happens to third-party rights? What happens to contract that he has entered into? What happens payouts he has made?
Because we had this scenario before.
Exactly. Is he going to refund? Now, these are some of the concerns. These are some of my own fears and concerns. I feel that we need to have something in place that in the period that your election is being contested, you need to step out or step aside and let the state apparatus be held in trust by an officer recognized under the Constitution, perhaps the Speaker of the House, perhaps the Chief Judge of the State, or if it can even be an independent person, to hold forth pending when the election is determined, so that you do not have a situation where the incumbent has access to the treasury of the state, to the funds of the state.